Welcome back to the Delaware Way. Clearing the juvenile criminal record of some adults so they can move on with their lives. Here to talk about that is Lisa Minutola, who is Chief of Legal Services at the Office of the Public Defender. Thanks for being here. I know Delaware keeps expanding the number of juveniles or number of adults who are able to get expungement.
Correct.
Explain that.
So last year there was Senate Bill 198, which was sponsored by Senator Brian Townsend, and that added some more categories of eligibility for individuals who had committed offenses when they were juveniles, who either have gone into adulthood without reoffending, or maybe have not yet reached adulthood but have had a significant amount of time between the time they offended and the time they're applying to be eligible for a discretionary expungement, meaning the court has to decide whether or not the expungement is merited.
It's not automatic. There's no blanket expungement.
Well, there's two types of expungements. There are some mandatory expungements where the court has to grant the expungements. Those are generally cases that terminated in someone's favor. So let's say you went to court and you had a disorderly conduct for a fight at school, and they decided there wasn't enough merit to prosecute you. Maybe it was a mutual situation, and they decided to drop the charges. So you're not found guilty or you're not adjudicated of those charges. That's something where you can apply for a mandatory expungement because you shouldn't have that on your record because you weren't proven to be guilty of those offenses.
And now the legislature is talking about expanding this even further?
So we're talking about expanding the discretionary expungement power even further. Right now there's a limit to how many adjudications you can have on your record. For misdemeanors, you can have some multiple adjudications. If you have a felony involved, it's generally you can only have up to one felony adjudication and one misdemeanor adjudication. What we're looking at is to take away the artificial limits of how many adjudications you can have. So instead the court can decide on the merit of the entire case and the entire record whether or not it's worthy for someone to have an expungement. A really good example of this is a gentleman that I met who is now about 50 years old. He had about 3 separate cases between the ages of 10 and 14 where he was adjudicated of a burglary second for breaking into a garage and taking a motorcycle for a joyride, an escape in the second degree, also a felony level offense, for leaving the Governor Bacon Center 30 plus years ago when he was placed there to go home to see his mother, and then he got another burglary third for again taking a motorcycle for a joyride. After age 14, he was released from Ferris. He was at the boys' school, was released from there, and then was able to go on, get a job, be in the same industry for 30 years. But because he had 3 separate adjudications, which included some felony adjudications, he's not able to apply right now to get an expungement, although he has no other record 30 years
But
past.
everything you brought up is nonviolent. They were all property crimes, unless you're telling me something else about the story.
Some of them are designated violent under our code. For example, an escape second, an escape from a facility is deemed violent under the Delaware Code.
But there are violent crimes that are either murder or assault or firing a weapon at someone. These are some violent crimes that people may have not be as forgiving as the state is on them. Violent criminals can be still expunged?
Some can. There are some prohibitions. So for example, a murder 1 or a murder 2, a rape 1 or rape 2, an arson 1, things like that are excluded from being expunged if
so the most
you
serious
are
violent crimes.
Right. If you are convicted in adult court, it's not a juvenile adjudication. It wouldn't be subject to juvenile expungement. So there are some safeguards for the most serious offenses that would not be handled in family court.
Are other states doing the same thing?
Some states have mandatory sealing or expungement once someone turns 18. Some states have much more expansive statutes than our state has. In fact, the Juvenile Law Center, which is a national organization out of Philadelphia, did a survey a few years ago of 50 states, and Delaware ranked somewhere around 45 or 46 in terms of the accessibility and the ease of getting a juvenile expungement.
Why is this important?
Well, it's important because as youth move forward, we want them to rehabilitate themselves. That is the mission of family court. That's the mission of the Children's Department. And so some children, like the gentleman I described, who's no longer a child, but they've gone on, they have become successful, and yet that record will harm them.
Thank you so much for coming in and explaining this to us. Lisa Minutola, the Chief of Legal Services at the Office of the Public Defender.
Thank you.
When we come back, a startling study that says 4 out of 10 students that graduate high school in Delaware are not prepared for college. We'll tell you what the Department of Education plans to do about that when the Delaware Way continues.